now move on to further legal orders from Southern Western Europe that sort of openly acknowledge and permit legal persons acting as directors and officers. And this session is presided or chaired by Giovanni Strampelli. He's a very kind colleague from Bocconi University. He has been teaching there for many years, and he is also a very prominent figure in Italian corporate law scholarship, particularly because he manages to sort of bridge the pond, if you will, as in he regularly cooperates also with people from outside Italy, which is not a self-explanatory thing to do in Italy. And so I think you are just predestined to chair the session. Thanks for being here.
Thanks,
Giovanni.
Many thanks for this kind of words and this kind of introduction. It's really a great pleasure to be here. And I am honored to chair this session on admitting legal persons to corporate board in Southwestern European legal system. I think that we have three very interesting presentation because I have the privilege to have a look at the slide presentation. So why I am saying that. So thank you. And I think that as we are a little bit late, we can move directly to the first presentation that is by Loes Lennarts, that is professor of Comparative Company Law at the University of Groningen. She's a very well-known expert in company law fields, European company law fields. She wrote some very important papers. I have in mind one about legal capital because I was writing my book on this when you wrote this piece. So that's why I know you through your scholarship. And she always is involved in policy. She regularly advises the Dutch government and other associations. And so thank you very much for being here. And the floor is yours for your presentation on Dutch legal framework.
Thank you. First of all, we are running late and I have far too many slides. So I'm going to start by saying that I will probably skip a few, but not this one. Yes, this beautiful etching was made in the late 16th century. And what you see here is the union of the blind man and the lame, or beautifully said in French, l'union de l'aveugle et le paralytique. And I read on the very reliable source Wikipedia that this is sometimes used ironically in reference to an unpromising relationship. Now, is that the case when one legal person is directed by another legal person? I think we have differences of opinion here. I still don't know exactly where I stand, but I'm just going to present to you the Dutch stance on this. And we are a bit the odd one out, I think, in Europe. First of all, brief introduction to board models. There are, as of 2013, two options in the Netherlands. The traditional one, for the larger companies, a board of directors and a supervisory board. I should point out that all the small companies usually don't have a supervisory board, they just have a board of directors. Legal persons can act as directors, which I have highlighted in green, but not as supervisory board members. I will talk a little bit more about that difference later on. We don't have any designation of a natural person as a permanent representative. I'm a comparative lawyer, as you all are here, so I put for you on the slide in contrast to Belgium, Luxembourg, France, and the rules for the EIG, which is more or less obsolete in the Netherlands, but I put it on the slide anyway. The board may consist of one or more legal persons only, and that is in contrast to current rules in the United Kingdom, which I mentioned because they always used to be more liberal than we are, but in this respect we are more liberal. We don't have this rule that at least one director must be a natural person. Now, as of 2013, we also have one tier. It's path dependency probably that has led us to make the same divide. So the execs can be legal persons, but the non-execs cannot be legal persons. I find that when I talk to even colleagues about the one-tier board, we very often tend to have in the back of our minds the dual board. So we treat the non-execs as supervisory board members. Now, this gave me a headache because I was trying to find out what is the ratio legis, ratio legis, we say in Dutch Latin. I couldn't really find much, I'm ashamed to say. The Dutch legislator acknowledges that the offices of directors and supervisory board members in principle require personal fulfillment of tasks. But this is not very well explained. And I checked the legislative history of some changes to the law made in the 80s, but it's just mentioned. But then why does it allow incorporated directors and why does it prohibit incorporated supervisory board members? It's quite sobering. The reason for allowing the incorporated directors is it's easy. It's useful for practice. It facilitates joint venture and group structures. Clear to you, I think it does away with the hassle of periodically dismissing and appointing individuals. Then why prohibit the supervisory board members? Yeah, legislator says no more than we want them to personally fulfill the task. And this has been questioned in recent years by some authors, but I will address this further in my paper. For time's sake, I will not go into detail here. We are very liberal because we allow multiple layers of incorporated directors. And I should point out that the legislator did not really give this much thought. It seemed to have the naive idea that this would not happen in practice. We would not see this very often. Similarly, foreign legal persons acting as directors also allowed. And here the reason why the Dutch legislator didn't see a problem is quite strange, because the reasoning is many systems prohibit incorporated directors. Yes, that's true in respect of legal persons governed by national law, but not in respect of legal persons governed by foreign laws. This blindness for my hobby, private international law. That I can skip because I've pointed that out, saves me some time. Now, the point I think is clear. We are quite permissive, but I am going to talk later on about some anti-abuse provision. Now, before talking about anti-abuse, I should talk a little bit about why maybe we should do something about abuse. But I also feel a little bit uncomfortable here because I don't know any numbers on abuse, actual abuse of foreign legal persons, because it would be very costly to carry out such research, so you're not commissioned by the Dutch government to do so. Now, there are two risks I see. The first one we have already discussed today to some extent, to avoid personal liability. We have introduced measures to counter this. The second one, and that's a little bit under the radar in the Netherlands, is it may create intransparency, especially in case of multiple layers, including foreign legal persons. You can use it to hide if you want to engage in tax avoidance, money laundering. I think Eva Michaela is going to talk about this. And we have not, or maybe not yet, addressed this effect of the use of incorporated directors. We have, of course, introduced legislation on ultimate beneficial owners, but we don't specifically we didn't do anything about directors hiding behind layers of legal persons. Eva is going to talk about this, the developments here in the UK later on. I forgot to mention I use this poster because this signifies untouchability, and you can become basically untouchable if it becomes very hard to find out who you are and where you are. Now, what is the anti-abuse measure that we have introduced? And I should perhaps say this was introduced in the late 1980s when we saw quite a bit of abuse of especially the private limited company, and the abuse taking the form of this company going into bankruptcy with a huge deficit, leaving all kinds of debts unpaid, also debts to the tax authority, but also regular creditors. So we introduced specific liability rule for mismanagement that is an important cause of the insolvency. And that is when the legislator started to think for the first time about, okay, now what do we do when we introduce this strict rule? And we have to apply it to a legal person who is a director, and maybe also thinking about the multiple layers. So we introduced a rule that extends that form of liability, but I will show you, and that is the slides that I'm going to skip, but it also extends internal liability and even tort liability. For brevity's sake, these will be addressed, at least this one. The final one, the director's disqualification, will be addressed in my paper. Now, this is the provision which has led to a fair amount of case law, including cases of the Dutch Supreme Court. I put it on a slide. It's very short, but it's very complex. Where a legal person is liable in his capacity as director of another legal person, any persons who are directors of this legal person at the moment when the liability arose shall also be jointly and severally liable. Now, the complexities that it gave rise to is which types of director liability are extended. Legislative history did not shed much light on that. Like I said, I will have to skip this topic, but I promise you I will address it in my paper. This one is also to be addressed in my paper if, as the Supreme Court decided, you say that also director liability on the basis of tort, which is an individual liability, is extended, then how does that work with the automatic joint and several liability? That is not the case. If we apply tort law, it's individual liability. Now, this I will address. What if the legal person to be pierced is a foreign legal person? And I will show that this article is then basically disabled. There are some ways to work around it, but that's not easy. If we talk about, maybe I should go back to, is liable in its capacity as director, with the 4 asterisks. Where is it? Sorry, I'm going back. Does this include shadow directors? Yes, the Supreme Court said. But on the other hand, any persons who are directors, so we call them the 2nd degree director or the 3rd degree of this legal person, you can ask the same question. There the answer is no, so it stops somewhere. And I should mention the shadow director is a concept that is only mentioned in this specific liability in case of insolvency. So we don't use it in the internal liability vis-à-vis the company outside of bankruptcy. But like I said, this article 211 and the liability in case of insolvency were introduced together. Now, this is how it works in a drawing, because some people like to visualize things. We have here a company that is directed by another company. And behind this company, this is a very simple drawing, not a cascade. We have 3 natural persons. Now, Article 211 operates in such a way that if XBV is liable on the basis of any of the liability provisions in our Companies Act, including the insolvency liability or tort law, then Article 211 makes these people liable. For tort law, I should explain a little bit more, but for brevity's sake, I will not do it. XBV must be a de jure or shadow director for the purposes of the insolvency liability incorporated in the Netherlands. This is to show you, also with a nice picture of the matrushka, that if we have more layers, and I could have added more, but only if these are Dutch private limited companies, this goes all the way to the top until somewhere you find a natural person, because that's the aim of the provision. You have to be able to reach a natural person. I will skip this for brevity's sake. Now, this is a little lion that doesn't yet have teeth, and Article 11 of the 2 can, in certain cases, turn out to be this little lion. So it can scream, it can roar, it can do whatever it wants, but probably it cannot bite if, as I have already mentioned, a foreign incorporated director is slotted in, because then the mechanism doesn't operate anymore. And like I said, the Dutch legislature did not really consider this, did not really take this into account, a little bit naive. This is a real case that went all the way up to the Supreme Court. Dutch company that was directed by Swiss GmbH. And behind the Swiss GmbH was inter alia Mr. Pieper, who was a very famous entrepreneur in the Netherlands, setting up all kinds of innovative projects, not all of them succeeding. That's not a problem. What was a problem was that the bookkeeping of this company was a complete mess. And I should mention that in our liability in case of insolvency, we have a presumption that if your bookkeeping is a mess, then that causes improper management, at least the presumption. And it also triggers the assumption that that improper management was an important cause of the bankruptcy. So this was a case where you could, as the insolvency trustee, you could have your questions about the management of this company. The trustee tried to get to Mr. Pieper, but came up against the previous decision of the Supreme Court that was confirmed in this case that said this is a Swiss company. And as I will show here, what does it mean? Well, according to Dutch private international law, we have to look at the lex societatis. And we use for lex societatis the place of incorporation. It's law, which means what? Well, we have seen that Swiss law has developed to a certain extent, but basically it boils down to a prohibition of the use of the legal person as such as a director. You can, as a legal person, name a representative, but you cannot say, I, the legal person, am a director. So this is a dead end. We have a dead end due to private international law. There is a workaround. Maybe in an exceptional case where the abuse was clear, you could say the case is clearly much more connected to the Netherlands. What was the reason for having this holding company in Switzerland, just a sham, no real connection? Then you could use this. But that was not an option in this case. And the other thing, which is interesting, you could also try to argue, because this was just one layer in between, that Mr. Pieper, was a shadow director of the bankrupt company, but that also failed, because he could point out that the management of my guy BV was left to other persons. And in fact, even the trustee himself had come up with that. So this was a no-go. I have to say, I don't know how often this occurs, but it's an option. And I've seen a few cases where people who make their business of defrauding creditors have used this, because word gets around and they know that this construction is available. Now, the question is, should we change the law in the Netherlands? And then what are the options? What should we do? Should we get rid of our Article 11 because of its complexities? And I have not even mentioned them all. Adopt the solution we're going to hear about shortly, the one that's used in Belgium, Luxembourg, and France, the permanent representative. Well, I'm afraid that if there would be any colleagues sitting in a room, and even worse practitioners, they would just say, no, we don't want that, because we will lose our flexibility. That's not what we want. And then we are going to change the law just for a few guys who abuse it, and we hurt the ones who benefit from. Then should we maintain it and restrict the use of legal persons as directors? And if yes, how? Well, we could say, I looked a bit at the proposal in the UK, so we could say all Dutch incorporated directors can only appoint natural persons as directors to limit the use to one layer. That would also solve the transparency problem to a certain extent. But what about the foreign incorporated directors, the problem I was talking about? Can we prohibit? And that's what they're going to do if it's done in the UK. They're going to prohibit foreign legal persons from being directors of UK companies. But can we do that? The UK is not a member state anymore. We are. So what would happen if we would say a Dutch company can be a director of a Dutch company? Great. But we don't want any foreign companies being directors of our companies. I think that would amount to discrimination. And then you would have to come up with a very good reason for making this difference. So I'm at a bit of a loss. I have one more slide, which is a little bit off topic, in the sense that you will recognize that I'm a Star Wars fan, R2-D2 and C-3PO on the slide. The first thing I can say about it, if we would in the Netherlands go so far as to give legal personality to the robot director, well, then there's no question, then they could be directors of Dutch companies. But for me, the question is, do we want it? Well, first of all, if we need a soul to be damned and a body to be kicked. And that's something that's often used. If things go wrong, we can solve that. We've also heard that today. We can use attribution techniques, or we could also introduce mandatory insurance. I think we are all clever enough and intelligent enough to solve that. But the most pressing problem here, to me, and we've also heard that to some extent, but this is also advocated by some authors who have written about it in the Netherlands, and I have to say doctrine is limited. There are only a few people discussing it at the moment, but some of them say, well, we have to be careful. For the first reason, we have now reached the level, and correct me if I'm wrong, that we have artificial intelligence, but we have not yet reached the level that there is artificial general intelligence. It has already been mentioned, I think the term AGI, where not just one specialized function can be carried out very well by using AI, but you can have AI on a board and it can oversee all the connections to all the other topics that can occur in a big company. So that's one thing, but the other thing is also that if you would not say, okay, AI is completely going to take over, which raises all kinds of questions, ethical questions, but if you would say, okay, AI comes on board and we have an AI director sitting together with persons. Now, how would that work in a board that operates as a collective? I think that's also quite problematic. Because under Dutch law, I don't know what it is in your systems, but we say there are some tasks that you can divide between each other, but the general business, or the general task of running the business, the strategy, but also large financial decisions have to be taken collectively, which means that you have to have this AGI version of the robot director to be able to take part in that process. Yes, I think I'm going to stop here. Oh, thank you.